Welcome to Summary Judgments, Understanding Illinois Personal Injury Litigation and Beyond with Mark P. Loftus.
Hello, today we're joined by Mark P. Loftus, a seasoned attorney with decades of experience in personal injury, employment law, and more. Mark's dedication to his clients is exemplified by his impressive track record and settlements. Mark, thanks for being here.
Hi, Kevin. Thanks for having me.
All right, so what interested you in the area of business litigation in Illinois? What was the draw there?
I got involved in that because I had a business acquaintance who had been referring personal injury matters to me. And she had this unusual situation with a very good client of hers. So she referred this individual to me. And it was a really wacky but sad case where he worked for a company that designed clothing and had basically brought them back from financial ruin and had grown the business substantially and they were doing well. But because of that growth and some other factors, they needed some credit. So he orchestrated some loans with a bank that I won't name. And while during the loan process, there was some paperwork that went awry. I won't go into the boring details, but the bank then took really aggressive steps to insert themselves into the company, which they did. They actually placed personnel at this business facility, locked my client out, and shortly thereafter, I shouldn't say shortly, it's probably more like a year or two, shortly after the business went bankrupt, and the bank sued my client and made a number of really harsh allegations, including criminal allegations against him. That case went to trial. I represent my client right up to the trial of that case. Then he was let out of the case. The case went to trial where the bank was suing the company and some other individuals. The bank lost the trial. My client then approached me and said, "Hey, is there anything I can do to recover for what they said about me and the allegations they made about me?" So I sued the bank for tortious interference with contract, where I basically alleged the bank took actions to invalidate my client's contract with the company. And I should have explained earlier, he had a contract with this company to kind of oversee their financials. And we uncovered more really glaring evidence of them inserting people into the company that were not qualified to run it. These folks generated reports that were clearly erroneous. They generated reports which suggested that my client had misappropriated enormous amounts of funds, none of which was true. And in the end, after several depositions wherein bank personnel had to admit that the reports were erroneous, that the personnel involved weren't qualified, that the allegations they had made against my client weren't appropriate or proper, the bank made a business decision and said, "Let's resolve this case," and the case was resolved. And I hadn't handled many cases like that, but that got me very interested in business litigation, and it's kind of different than personal injury litigation. There's different issues, there's different damages assessment, and it's that kind of stuff I like to do because it makes you use your brain in different ways, and it makes you learn new areas of the law, learn how to introduce different types of evidence, and make different arguments to a judge or a jury. And ever since then, I've been handling business cases as they come along.
But sort of the same, and the same thing as far as you're helping someone who is going through a tough time, whether that's personal injury or like that's a crazy story, and then you've got somebody who's obviously seriously wronged in a different way than personal injury, but sort of similar at the same time, like this defamation of character, financial, and all that.
Yeah, it was, and a wonderful, wonderful guy, and it took an enormous toll on him. I mean, it really did. Yeah. And he's still dealing with the fallout from all that. It was a very, very difficult situation. I've also had a number of cases, some interesting cases where, for example, I represent I don't want to specify, but I represented a woman who was in the healthcare field. And she had certain individuals working for her in the same field. And it became apparent after a while that this one individual had come into the practice, had worked under the auspices of my client for a year or two. And it became clear that she had kind of devised a way to siphon off patients to a different practice that she later joined. So in other words, it appeared that there was a scheme to maybe direct patients from this one practice to the secondary practice, which is again inappropriate and wrong. And I got involved with that case and was able to demonstrate that. It was pretty clear from some emails, texts, and those sort of things that there was a scheme in place, and that case resolved favorably as well. And I've actually had several of those cases. Word must have got out after the first one. I've had several similar entities contact me about those cases.
Healthcare and dentists.
Right.
That's your deal. So besides that, what other types of business law cases do you handle? Like, what are the common ones that you see?
There's your standard breach of contract cases. I handle a fair amount of fraud cases. I've handled a number of Real Estate Disclosure Act cases, which is where a sale of real estate in Illinois, and there's the seller makes representations about the lack of defects in the property, and turns out there's enormous defects in the property. Basically a fraud case in Illinois. I've handled a number of those. I've been doing those for many, many years. I've represented defendants in those cases. I've represented plaintiffs in those cases. The reason I got involved is because my first and only time I represented a defendant, he had sold a business property to another business that was absolutely riddled with termites. It was bad. I mean, the evidence was overwhelming that he knew about the termite situation, although he denied it. But there was all kinds of documentary evidence that he was well aware of the termite situation. And that was a settlement well into the six figures. I represented the defendant on that case, and since then have represented numerous plaintiffs who have purchased property with defects in the property. The more serious cases typically involve structural issues. Mm-hmm. I settled a case, I think 2 years ago, where this poor woman's, the back portion of this woman's house was actually caving in. You could go in with a ruler. You could walk through the house. As you got to the rear portion of the house, there's a 4 to 5 inch differential in the rear of the house.
Oh, wow.
And it turned out that there had been substandard structural elements put underneath the house that were basically collapsing inward.
Holy cow. They think they're going to get away with that. People are going to figure that out. The termite one. I mean, do people just think that I can deny this and that'll be good enough? They figure they give it a shot? I mean, I don't know. That just seems like such a Hail Mary.
In the termite one, my client was a good guy. I frankly think he had used the property as a business property. I think he had then moved and wasn't really using it. And I think he was basically using it as storage and just wasn't there. And I think he had forgotten that he had signed certain documents from termite inspection companies and all that. So that was bad. The other one, the one I mentioned where the rear portion of this poor woman's home was collapsing inward. Unfortunately, it's not uncommon in the Chicagoland area where you have builders and developers who flip properties. They buy properties cheap. They dress them up cosmetically and then make them look nice and then sell them. And they don't address significant issues of which they're aware, which is what happened in the case with the woman with the structural sinking. It was a couple of guys who had gotten together and purchased the property and slapped some paint on and put some new cabinets and new windows in, and were well aware, because they were builders, were well aware of the defect in the back, and just cross their fingers and hope that she wouldn't find out.
Yeah, I've heard that with like some shady car dealerships, like used car dealerships, where they just make it look really nice, but they don't do anything else to the car, and it's just a piece of junk and a lemon, basically. And yeah,
that could be true in the car. But I don't really know about the car business. I do know, unfortunately, in the Chicagoland area, there's lots of developers and builders who love to flip houses and don't, and either mask or try and hide the defects that they know about in the house.
So how does the litigation process differ for small businesses compared to larger corporations in Illinois?
Well, the biggest difference, I think, from a practical standpoint, is small businesses, obviously, legal fees impact small businesses, tougher basis than a big, giant corporation. I've represented lots of smaller businesses in litigation, and obviously they're always concerned about their budget. And I try and incorporate that, and I try and make it reasonable for them. But litigation can be expensive, and I tell clients that I had a discussion with a client yesterday on a fraud case in terms of his home, and he wanted me to kind of assure him that it would not devolve into expensive litigation, and I told him I couldn't do that. Litigation can and does get expensive, and you need to be prepared for that.
Do most of these business disputes lead to litigation and trial as compared to personal injury? Are they about even?
That's a good question. I don't know what the breakdown would be with the business disputes. I have tried a couple of business disputes to judges and juries, less so than the personal injury cases, but only because I have probably more personal injury cases on my docket. On the business side, business people tend to make business decisions, and they tend to recognize early that if the evidence is not in their favor, they want to stop the bleeding and resolve the case.
Right. That makes sense. So there's something called alternative dispute resolution, or ADR. Can you explain what that is and what its role is in business cases?
Sure. ADR is a huge component of the personal injury practice these days. And what ADR is, and actually I think the biggest one in Illinois is about 2 floors below me in this building, is it first came into vogue probably about 25 years ago. That's when I did my first one, where you have an individual, a man or a woman, nowadays almost always a former trial judge, now retired, who joins a service who markets themselves as an alternative to going through an expensive trial. And alternative dispute resolution is founded on the concept that bring this matter to us. We have seasoned, experienced trial judges who know the issues, who know the law, and we can sit down over the course of several hours and effectuate a settlement. And the biggest selling point of alternative dispute resolution is it brings you finality and certainty. The parties agree on a specific arbitrator, like I said, or mediator, which is almost always a retired judge. And then prior to the mediation, both parties submit briefs describing the case, describing their theories, describing their damages, and the mediator reads those materials, and then the parties gather. In the old days before Zoom, they would typically gather, like I said, the ADR service in this building has multiple conference rooms, so you'd all meet in a conference room, introduce each other, have some brief remarks, then the mediator separates you, and then the mediator typically comes into my conference room where I am with my client, and typically the mediator starts up by saying, I'm sorry that you've gone through this, you suffered some significant injuries, however, I think you may have some issues with liability, or I think some of your damages may not be recoverable. And they try and typically the briefs will include the plaintiff's demand and the defendant's offer. So there are parameters when you start, and the mediator is aware of those parameters. And the mediator tries to bring the parties close together and eventually reach a number that both parties can live with. It's become extraordinarily popular in Illinois. Most of the mediators are great and real smart and very effective at what they do. The mediation, however, is expensive because the mediators are entitled to charge for the time, and so that can be expensive. You can be paying a mediator several $100s an hour over the course of several hours, sometimes days, to work on your case and get it settled. So it can be expensive. However, it is extraordinarily effective in getting matters settled. I think in my history, I would have to put the number up at close to 80%, the likelihood of a case settling, in my personal experience, if it goes to mediation. It's overwhelming number of cases that go to mediation resolve.
Is it a quicker process?
It is quicker because you're doing it informally. You're not putting on witnesses. You're simply having a discussion with an experienced judge who's a good person to evaluate the case, and a judge who's familiar with similar jury verdicts, who's tried lots of cases, and you dispense with witness testimony. You tell the judge what the witnesses are going to say, so he knows what the testimony is going to be. He knows what the evidence is, and he or she makes a pretty educated determination of what the value of the case is, and tries to work toward the parties toward a resolution of the case. It can stretch for 2, 3, 4 hours. It can go all day. It can sometimes go, depending on the really complicated medical malpractice cases, death cases, products cases, it can sometimes take a couple days. But that's certainly shorter than a 2 or 3 week trial, where you have, even if you have a great case, sometimes things go crazy at trial and you get a result you really don't like. So the primary benefits of mediation are it brings you certainty and finality. If you agree on a number, the other side, the defense side, will pay it. There's no appeals. It's over. That's the biggest selling point for mediation.
Yeah, it would have to be a situation where both people are willing to do that, though. I would assume, like
both parties have to agree ahead of time.
I could see one of the sides like not wanting to do that because they're afraid that they're, if they think they have like a legit chance of going to trial and winning, like as a defendant, you probably wouldn't want to do that then, right?
Yeah. And the other thing is, before mediation became a big deal, I'm showing my age, but before mediation became a big deal, parties used to do pretrial conferences, which was where you'd agree to a specific sitting judge, and you'd go to that judge and see if the judge could settle the case. I've done like too many to count of those. And pretrial conferences are free. It doesn't cost you anything. It seems like mediation has become very, very, very popular. And I'm certainly doing now more mediations than I am pretrial settlement conferences.
Interesting. All right. Well, thanks everyone for tuning into my conversation with experienced attorney Mark Loftus. For more information or to connect with Mark, you can visit markploftus.com. As always, don't forget to like and subscribe as well. Mark, always great to see you. Thanks for being here.
Thanks so much, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.